All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey. People represented by Ms. Clark, Mr. Darden, Ms. Lewis. Jury is not present. Counsel, anything else we need to take up before we invite the jurors to join us? All right. Ms. Clark?
We advised the court in chambers. We had filed a motion this morning requesting that this matter be conducted as a conditional examination on videotape, and we are prepared with the means by which to do so. The reason that we have made this motion, we have not been afforded an opportunity to be heard on whether this would be a conditional examination or in the presence of the jury. And we acknowledge the court's discretion in this matter. Nevertheless, we feel that it would be
I thought we had this discussion several times Friday.
No, we did not. We asked for time to consider the option, although our position had been previously consistent that we wanted a conditional examination. We did not want to take the witness out of order in the middle of our case in chief. At the 11th hour yesterday, the court asked us again to reconsider, and we stated that we would consider, but we were never given the option of arguing to the court what our position would be. We considered the matter and determined that we did not want to proceed in the presence of the jury, but we were not afforded an opportunity to be heard in that regard. We were not. We have...
No, we discussed this a half dozen times, counsel.
We discussed it at sidebar at the last opportunity. The court inquired of us, I believe, on Friday, whether the people continued to object to her being called in our case in chief out of order and in the presence of the jury, and we said, yes, we continue to object. Then we went to sidebar at the end of the day, and the court asked whether or not we wanted to have it, the court indicated that whether we wanted to consider having her in the presence of the jury, and we said we were considering that other option. But we have not had an opportunity to present to the court our position on this since that time. And I would like an opportunity to do so. I think that the people's right to a fair trial is substantially endangered by this procedure. Number one, by allowing the witness to be called out of order in the context of the middle of the people's case in chief. This highlights the witness's testimony, affords her undue importance, highlighting her above all other witnesses, which is unfair to the people's case. But beyond that, Your Honor, it's very disruptive. The people will then have to present rebuttal testimony, which is only in its embryonic stages and being formulated. There's a great deal of impeachment against this witness, a great deal, Your Honor. We've been investigating her all along. It's not that we waited till the 11th hour to do so. However, we were always of the belief, and it was a well-founded one, that the ultimate rebuttal would not occur until rebuttal in the people's in the ordinary course of things. That is, that her testimony would be presented in the course of the defense case, and that we would be afforded the opportunity to present rebuttal of her testimony after that, when the people's rebuttal began. So there was at least a 2 to 3 month window in which to further develop all the leads. Even this weekend, we've been obtaining substantially new information. To preclude us from getting all of that information and to require us to basically prepare for cross-examination in one weekend and then cross-examine this witness that the defense contends is a key witness for them, on which their whole case hinges, is basically to deprive the people of the opportunity to have an effective right of cross-examination and confrontation. Not only does it rip the fabric of the people's case at a critical point in time, but it also prevents the people from conducting the thorough kind of investigation that we're entitled to conduct with respect to this witness's credibility, which the court is already aware is substantially in question. We ask only that the people's right to a fair trial be preserved by affording the defense the conditional examination that they initially requested. Although the people's position has not changed that the granting of the conditional examination was not required based on the testimony given, that perhaps the 1332 of the Penal Code, a material witness section, would have been appropriate to protect their right to have that witness present. The court...
You want to incarcerate a witness for 2 months?
No, the witness can post bond. The defense has been giving this witness money, feeding her, clothing her, housing her, paid for round-trip tickets for her. I'm sure they would post bond for her as well. No, she need not be incarcerated. The court's aware of that. The court's also aware of the defense funds and the defense ability to make sure that she can post the bond. That option is available and the people urged the court to take it. Nevertheless, the court ruled that a conditional exam would be afforded to the defense for this witness. All the people are asking now is that the court hold to that ruling and conduct this as a conditional examination so that the people will have the ability to present their case in an orderly fashion, complete the investigation that they've only been given a weekend to speed up.
I thought you said that the prosecution's been long aware of this witness.
The prosecution was aware of this witness and was conducting investigation into this witness. Nevertheless, her lack of credibility was so apparent that we could never have anticipated the defense would hinge their whole case on her. Moreover, the defense has made representations concerning subsequent statements by this witness that we were never made aware of, and to this date have no written statement on. We have only counsel's representations in the opening statement as to many of the things she's going to testify to. And I'm sure we're going to hear another version on the witness stand today, whether that be by conditional examination or in front of the jury. But the people's right to a fair trial is in jeopardy here. And I think that there's no detriment suffered by the defense if we present the conditional examination and videotape it. Don't forget, Your Honor, that they will still have her present and available to testify in their case if they want to put her on the witness stand. They will have the option. If they decide that they don't like this witness, they can put it on through videotape or not play the tape at all. If they like this witness and they see that she does a good dress rehearsal, they will have her present for their defense case. And I think that no one should be in any doubt about that. She'll be here. Nevertheless, if we do present the conditional this as a conditional examination and videotape it, the rights of all sides will be fully preserved. But to rip the people's case and to basically stop the examination and interject a defense witness that will require lengthy cross-examination and lengthy rebuttal pertaining to facts that have not yet been presented even in the people's case will be confusing and misleading to the jury, will curtail the people's right to an effective cross-examination, and will curtail the people's ability to effectively investigate her. And I'm asking the court, in the interest of justice, to allow this as a conditional examination that will protect everyone's rights.
How do you propose to prepare under Evidence Code Section 770, if you haven't already?
I'm sorry?
Well, if you're going to confront her with inconsistent statements, don't you have to do that now during the conditional examination? Are you prepared to do that?
Yes, and I think that, first of all, we can do that by being given broad latitude in cross-examination, which I'm sure the court would afford us, given the unusual nature of these proceedings and the fact that it is a conditional examination. And we can ask those kind of broad, far-reaching questions on cross-examination that will subsume the issues, many of the issues of prior inconsistent statements.
Mr. Cochran?
I thought I would not be amazed anymore, but it's amazing that, if the court will recall, at the end of the day, on Friday, Mr. Darden was saying how he looked forward to having Ms. Lopez before this jury. In fact, he made this statement: "I wonder who's going to clean up the blood after I finish the cross-examination." And I welcomed him. I said, "Well, you go do what you do. We have a truthful witness here." This was litigated, and as always, the people, you know, it's beyond disingenuous for somebody to come into this court at 6:30 after you've brought all these jurors over here. We're ready to proceed, and the witness makes a promise to you she'll come back, and they say, "Well, we can't do it tonight, Judge, because I got to pick up my children," and the court is sensitive to that. And it was a ploy for them to go and try to cry and moan over the weekend and come up with some other document. For Ms. Clark to stand up here and talk about the defense doing this, she doesn't know anything about the defense. If she thinks that our whole case hinges on this witness, then she, like so many people who write about this case, don't know what they're talking about. They're not even part of this case. We have a number of witnesses, all of which they know about. So it's preposterous for them to say that. This is a witness, Your Honor, who's going to be leaving. The court has ruled on this matter. We all come back to court prepared to do this. They're prepared to put it over just till today to proceed. And then all of a sudden we get this motion where all of a sudden they're being prejudiced or whatever. It's the usual thing, Your Honor. And for her to say that our whole case hinges upon this witness, it's preposterous. We have a number of other witnesses, and they are very much aware of it. And specifically, the court has ruled on this. They agreed to it. We talked about it, as you said, a half dozen times. And when we asked for the delay on Friday night, you look at the transcript, they didn't say, "We don't want to have her testify before the jury." They said, "We just can't do it tonight because even though Mr. Darden is going to be conducting the examination, Ms. Clark has to be here to see and advise him and tell him what questions to ask." And that was why we put it over. We went through this in detail. And so Clearly, Your Honor, this is another attempt by them to avoid facing up to what they have to face up to in this case, and we're ready to proceed. And we should proceed. The Court's ruled on this. It's the honorable and fair thing to do, and all the rest of it is wild speculation on their part and totally disingenuous. I'd ask the Court to allow us to proceed at this point.
I'm offended as a woman, as a single parent, and as a prosecutor and an officer of the court to hear an argument posed by counsel like that of Mr. Cochran today. Some of us have child care issues, and they are serious, and they are paramount. Obviously, Mr. Cochran cannot understand that, but he should not come before this court and impugn the integrity of someone who does have those considerations. And I'm deeply offended. The people, I would like to indicate the people are strenuous and vigorous in their desire to have this witness testify. We want the ability to fully and effectively cross-examine her. We feel that it would be the fairest thing for both sides to do that in a conditional examination. What the court nor the people could not know on Friday is that new information would be obtained over the weekend, which it has been, that will provide fertile ground for a more effective cross-examination. This information needs to be followed up. It will also afford us the opportunity to present our rebuttal effectively, having gathered all of that information at one time. If we have to present this witness before the jury now, we will be required to present some rebuttal now and then some later in a disjointed fashion. The people have to be able to try their own case, as does the defense. And the order of witnesses is a very important matter that we know the court is aware of. The ability to structure a trial strategy that most effectively conveys the nature of the case and the information that is required to be conveyed to the jury is a very, very important matter. It's not one to be taken lightly. This is why the defense is so desirous of having this witness taken out of order. Even if she doesn't come across effectively, the jury is adequately confused so that her testimony, even though may not be believed, will simply rent the people's case sufficiently to cause confusion and distortion of the people's case. All we want is for the ability to effectively and cohesively present our case to the jury. The defense has already persuaded the court to effect the order of witnesses that the people had proposed on the domestic violence issues. The defense now seeks to do it again, but without good cause, Your Honor. The people submit that there are substantial issues of fairness of this trial, the people's effective ability to cross-examine, and to present the case to this jury that we are being deprived of by having this witness taken out of order. We do feel that everyone's right will be adequately protected by a conditional examination, but please bear in mind, Your Honor, that our investigation of this witness is actively ongoing, has been, but certainly went into high gear over this weekend, and a number of new matters were brought to light. So we would ask that the court take the witness's testimony today, but allow us to do that as a conditional examination. At the appropriate time, if the defense desires to play the tape, they'll have the option of doing so, providing they can show due diligence. But I suspect that the witness will be available to be testifying in person at that time. Either way, it's a no-lose really for the defense, but at least it affords the people the opportunity to present a cohesive case and to effectively investigate and cross-examine this witness.
What's your time estimate, Ms. Clark, for the presentation of the remainder of your case? Realistically now, would you say perhaps the end of March?
And based on what we've seen, the way testimony is going, I have a better feel for the pace. But I need to talk to the people who will be presenting the blood evidence and the DNA evidence to really give a good idea. So I'm going to give it my best shot, Your Honor. I think that's probably fair, the end of March. I think so. You know, I mean, if you really want me to get more specific and more accurate.
No, just sort of a ballpark guess in asking you how much disruption this is, just to put this in context.
We haven't even gotten to, let me help with that. We haven't even gotten to the testimony of the witnesses that make Rosa Lopez relevant. We haven't even gotten that far. We haven't gotten the testimony of Cato. We haven't gotten the testimony of Alan Park. These are the key witnesses that make Rosa Lopez's testimony intelligible. So we are going to be wind up rebutting testimony that has not even been, essentially, they're putting on their rebuttal before we put on anything directly to make that intelligible to the jury.
All right. Thank you, counsel. Well, certainly make my life interesting every day. I appreciate the fact that both sides anticipated going forward with her testimony before the jury today. The original defense request was for a 1335 conditional examination, which I granted. And after our discussions, I was under the impression that both sides agreed that it would be better under all circumstances than to have Ms. Lopez testify before the jury, since that is the ideal situation. However, the rights of both sides will be protected under the 1335 procedure, so I will modify my order and we'll proceed. Yes, briefly.
I was not going to respond to the last thing the counsel said. But, Your Honor, both sides did in fact agree. And the fact that the people have now come in and changed that is, I think it's just outrageous, Your Honor. We can never have any closure in this case on anything because they changed their strategy, they changed their mind from day to day, Your Honor. And it seems to me that this would be, the court has not ruled yet, counsel.
Just did, Mr.
Okay.
Cochran.
Well, Your Honor, you had ruled also on Friday night. So they're back up here talking, so I think I should be permitted to at least indicate this.
Well, no, Ms. Clark is correct in that after I made the decision, I told her, she said she wanted to be heard, and then the other issue came up with child care, and then that sort of closed the whole issue for the evening as far as I was concerned. And frankly, since we had been in session 6 hours beyond our anticipated closing time on Friday, I was ready to call it a night then.
Never mind the court. What happened was Ms. Clark was now gone at this point. The court, we called the jury then at the end of the day and said we'd be calling a witness out of order to testify, and this was a decision. Right. It was a made decision.
You're right.
Everybody in America is looking in, is aware of this was a made decision, and then they come up with this motion that nobody knew about. Darden had agreed to it, and John, I think that's totally unfair. It was unfair
Mr. Cochran,
that they would do this.
I agree with you in many respects. However, you asked for initially a 1335, so you won the day. You got your 1335. Ms. Clark now brings up good points. I'm more than willing to change my mind when I feel it's appropriate.
Unless, can we just talk for a moment about her good points? The good points are these, Your Honor.
Well, Mr. Cochran, we've had the opportunity to argue it.
Well, it's just, you know, I would just submit to the court that this is outrageous, that they would be able to come back in and reconvince Your Honor after we made a decision. You're going to do this on Friday night.
Well, Ms. Clark raises the possibility that if we put on Rosa Lopez now, then they're going to bring on 5 rebuttal witnesses, which is going to totally derail things.
Your Honor, they're always claiming things like that, and it turns out to be much ado about nothing.
Well, that's what I would do if I were them.
Right, but it turns out to be much. So let them do that. I mean, they were going to be so ready to do this. Judge, they've known about this witness since last July or August.
Excuse me, Mr. Cochran, forgive me for interrupting you for just a second. Ms. Hazel, would you ask Mr. Schuman to get his gear together for me, please? Thank you.
Your Honor, it seems to me they've known about this witness since last summer. And the fact that we get information, Judge, in this case, this very morning, at this very moment, people are calling in on both sides. It's just totally disingenuous to say we got new information. We get new information minute by minute in this case, and will continue till this case goes to the jury, Your Honor. It's another stall as they did Friday night. And you know, Your Honor has been wise and fair in this case, but certainly you can see through this. And for her to say that I'm not sensitive to child care is preposterous. What I'm sensitive to is the fact that they came in here and said, we're ready to go on Monday, but I just have to be here so I can advise Chris Darden. And now we come with this motion. And that's the thing. So I just wanted to at least have the court indicate how strongly the defense feels about this. I think that I don't want to see this court snookered by this. I mean, this stuff about a fair trial, I mean, it works both ways, Judge. They have the power of the state. They have the entire police department, DA's investigators. They've got everything. They've known about this witness since last summer. And for them to come in here now and say, we're not ready, Judge. I mean, we hear this time and time and time again. And I just think it's unfair because the defendant's entitled to a fair trial also. And the court had made its decision. We live with that decision. And as usual, they come back and begged and moaned and asked you to do something else. And you rightfully consider those things, Judge, but it seems to me in this instance, given this record and what you said, I mean, they affect your credibility. We tell the jurors, we would have done this Friday night. You tell the jurors, we're going to take this witness out of order, come back Monday morning, we're going to do it. Ms. Lopez, who stays over, says, I'll do that for you, Judge. And you say to her, Judge, you say to her, I'll get you on, we'll testify before the jury, and it'll be over with Monday morning, and you can leave if you want.
What she anticipated was coming here and having her testimony tape recorded, which is what we're going to do.
Well, not as of Friday night. She anticipated having it over. What they're arguing, and you know what they're doing, Judge, and let me just say this last thing, and I'll sit down. They're also...
Wait, Ms. Clark.
Judge, what they're doing, again, is seeking to re-argue everything. They're saying, in their motion, when you rule that Rosa Lopez would leave to go to El Salvador, and they don't like a ruling, they try to come and circumvent it by every way they can. So what they're saying now is do this conditional exam because we know she's going to really be available, which is contrary to what you had found the circumstances. So they ask you to re-argue that particular point, Your Honor, and it just seems to me that's unfair. What happened is, this case is the strings are being pulled by others that are sitting here at this table, and they come here and make a representation, and they go back and they have to talk upstairs and get their new orders, and then run down here and make these things,
Ms. Clark, please don't interrupt counsel.
And so what you're seeing, Judge, and they want to put you in the middle of their battles upstairs when one person says something, and that's not fair. And that's why you're the judge to make these rulings and make them and stick by them. So I just think we should be able to go forward as we kept. I mean, I think it affects everybody's credibility when we tell jurors something and then all of a sudden they come up with this last-minute attempt. So I'm just saying to the court, you ruled. It was an appropriate ruling, given all the evidence. We should proceed with the testimony. And if they want to call 5 rebuttal witnesses, they've had all the time in the world to do that. They can call anybody they want. They were so worried about whether or not we want to call this witness. We'll make it very clear. Remember, I stood up and I invited him. I said, let's put it before the jury. You're so worried about everything. Everybody around America is worried about Rosa Lopez. We made our decision with regard to that. It's been abundantly clear. You don't see us changing our strategy every few minutes, but where they have. And I just suggest to the court that that's not fair to the defendant when we talk about what's fundamentally fair. And I would ask the court to think about that before you reverse your well-thought-out and well-reasoned ruling.
Thank you, Mr. Cochran. All right, counsel, we had not started the actual examination of the witness. What you had asked for was a 1335 conditional examination. I granted that. Since the jury was available, I decided to do that. Since then, the prosecution has brought to my attention a point that I had not contemplated, and since we had not embarked upon that course of action, it's not inappropriate for me to change that, which I'm going to do. We will take a 20-minute recess to allow the videotape equipment to be set up, and we will proceed. And Deputy McNair will need to transport the jury up to the holding lounge upstairs. Mr. Darden.
Your Honor, before we break, I've asked defense counsel, and I've asked on the record as well for any notes and recordings relative to any interview they had with Miss Lopez. I have not received any notes or any recordings of any interview they may have had with her, and I'd like to inquire of defense counsel if any such notes or tape recordings exist.
As far as other than talking, we have no notes and I don't have any recordings. I inquire with you. I can do is call Mr. Paddle. That's the only person I can call.
Well, we understand, Your Honor, that over the weekend, Mr. Schiller, who is apparently Mr. Simpson's personal biographer, spent some time with Ms. Lopez, and I'd like to inquire of Mr. Schiller if he has notes. If he interviewed Ms. Lopez, I'd like those notes, Your Honor.
Is he kidding, Your Honor? That's how bad their information is, Your Honor.
If that's a denial, Your Honor, that's fine.
Are you indicating, Mr. Cochran, that that's not true?
As far as I know, he didn't talk to her. He's got to talk to her.
All right.
That's fine.
All right. Very good. Mr. Walsh, you had something?
Yes, Your Honor. Mr. Douglas has made an ex parte application for an order shortening time. If the court's not going to consider that now, may I be excused?
No, I'm going to consider that now.
All right, thank you.
Mr. Walsh, do you want to address that?
Yes, well, thank you, Your Honor. We received the application this morning indicating that the defense became aware on February 22nd that there may have been certain investigations into allegations against Detective Furman. They're now asking that the court issue an order shortening time till March 2nd to have a hearing on whether those documents, if they exist, should be produced and disclosed. I'm at a loss to understand why they waited until this morning to prepare these documents and file them and give them to me. It's a very short period of time for the city to analyze the request and make a determination of the stature and position that it wants to take. The only reason given in the declaration why an order of shortened time should be allowed is that they believe that Detective Furman is to take a stand on March 1st. I have no information as to whether that's true or not, but March 2nd is an inconvenient date for me for two reasons. One, I have a prior appearance that morning. Second, I have a funeral that I must attend tomorrow, so I would have a limited amount of time to respond to the request and to determine what the city's legal position would be.
How about March 3rd?
March 3rd would be better, Your Honor.
All right, March 3rd,
Thank you. What time?
9 a.m.
Thank you.
Thank you, counsel. All right, Ms. Robertson. Let's, okay, we're going to take a recess to set up the videotape equipment, and we'll resume as soon as the equipment is available. Thank you, counsel. In the Simpson matter, record should reflect that we are about to conduct a conditional examination pursuant to 1335 of the Penal Code, and that the court will be sitting in this matter as a magistrate. All right, Mr. Schuman, are you ready? Mr. Firth, are you ready? All right, Mr. Cochran, you ready?
Yes, let me put you in.
Yes. Simpson is again present with his counsel. Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Ms. Lewis.
I have a matter, Your Honor, I'd like to bring to the court's attention, and it was the subject of some discussions that we had in chambers. Your Honor, as the court is aware, Your Honor, this morning, a document which is a two-page statement written by an investigator and addressed to Mr. Shapiro concerning Rosa Lopez was turned over to the prosecution after having an in-camera review with the court. That was a document that is dated July 29th, 1994. Now, Your Honor, I was under the impression that that document had been turned over to the prosecution consistent with other documents that we had turned over on September the 1st, 1994. Indeed, Your Honor, when we discussed with Ms. Lopez last week the substance of her testimony, we were discussing it within the context of the July 29 document. That document, Your Honor, included reference to an undocumented housekeeper who is named Sylvia, who is acquainted with Ms. Lopez, and who was present on some times that are not critical nor germane to the substance of Ms. Lopez's testimony. Ms. Lopez had expressed severe concern that the Sylvia, and she is not aware of Sylvia's last name, but that Sylvia, since she was undocumented, did not want to have any involvement at all in this particular case and did not want her name mentioned at all in any reports dealing with Ms. Lopez's statement. It was with that context that Mr. Pavlik generated a second document, which was an interview of Ms. Lopez which occurred, and that document was dated August the 18th, 1994. It is the August the 18th, 1994 document that was turned over to the prosecution. I have, Your Honor, in the interim since this morning, checked with my office to see whether my office had any record or knowledge of the August 18 statement, because it was not among the documents that I used to help discuss Ms. Lopez's testimony with her this past week. And I was told that we did not have the August 18 document in our particular file. I learned about the possibility that such a document existed when I spoke to Mr. Pavlik on Sunday, complaining that Mr. Pavlik had included in his report to the prosecution a name that Ms. Lopez had wanted to not be included. It was then that I learned, and I verified it when I checked my own documents here in court, that in fact there had been a second report, the August 18 report, that was in fact a two-page document of Ms. Lopez, just as the July 29 statement was a two-page document of Ms. Lopez. That is where my confusion was born, such that when I saw that there was a two-page statement of Ms. Lopez, I thought we were talking about the earlier statement, and I was not aware of the existence of the August statement. I anticipate that Ms. Clark will stand before you and express some shock, some outrage, and some sense of prejudice. I would like to say these words in response, however. The August 18 statement that was turned over to the prosecution is more detailed in terms of the germane facts of Ms. Lopez's testimony. There is more inclusion, for example, in the August 18 statement about the circumstances of the June 13 interview between Mr. Furman in the morning and Ms. Lopez. More information was contained in the August 18 statement than was even in the July 29 statement. The August 18 statement was created simply to assuage Ms. Lopez's concerns that her undocumented friend, who did not want any involvement in this case, might come forward, her name might be released, and she might then be interviewed or some way involved in this case. However, Ms. Lopez told me, and told Mr. Cochran when we were discussing that statement, that she had had subsequent conversations with this Sylvia, and that Sylvia had in fact been interviewed by Los Angeles Police Department officers months ago. That Sylvia in that interview had denied any acquaintanceship with Ms. Lopez, knew her only briefly, and did not have any information to lend to anything concerning this case, which was consistent with the statement that Sylvia told Ms. Lopez that Sylvia did not want to have any involvement in this case and would deny any subsequent involvement in the case were she to be asked about it. Therefore, Your Honor, if there is some claim that there is some surprise, that there is some prejudice, I think that you should inquire whether or not this Sylvia person has ever been known to the prosecution, whether or not this Sylvia person had ever been interviewed by the prosecution, and she was in fact interviewed, as I said, months ago. Her relevant involvement in this particular case is not germane to the substance of Ms. Lopez's statement that sometime after 10 o'clock she went outside walking her dog and saw Mr. Simpson's Bronco in a location identical to where she had seen that Bronco earlier in the evening. The only context with which the Sylvia information has any sort of relevance is to explain why at approximately 8 o'clock Ms. Lopez was outside waiting for Sylvia to come over and thereby saw Mr. Simpson's Bronco parked in the same position as it was parked later after 10 o'clock, and why sometime after 9 or 9:15 Ms. Lopez was outside to see Mr. Simpson leave and to notice that he had left in his Rolls Royce with another man who we now know was Cato Kalin when they went to go get a hamburger. The statement in August includes mention of Ms. Lopez being outside at 10 o'clock and seeing the Bronco, includes mention of Ms. Lopez seeing Mr. Simpson leave in his Bentley after 9 o'clock with an unknown person, and then learning that there was some hard-soled shoes walking down Mr. Simpson's property about 20 to 30 minutes after he had left to McDonald's.
Excuse me. If Ms. Lopez is here, can we have her step outside?
Mrs. Hamburg, why don't you and your client step outside while we're discussing your client's potential testimony, please? Thank you. Please wait in the hallway. Thank you, counsel.
But, Your Honor, any involvement or any mention of Sylvia or any relevance to anything that she may offer is really collateral and tangential to the substance of Ms. Lopez's testimony. The statement that we gave in August is more complete as to what Ms. Lopez will testify to than the statement that was in July. The prejudice, if any, is minimized because the people have already interviewed this Sylvia. The people have a statement, I would assume, although I have never seen any reports of the interview of Sylvia, but Sylvia told Ms. Lopez that, in fact, she was interviewed by detectives or police officers shortly after the incident occurred months ago. And therefore, Your Honor, I think that, yes, there was a problem because a two-page report that predates the report that was turned over was not actually turned over. However, the report that was turned over is more complete in terms of the testimony that Ms. Lopez will give in this trial. And the reason why the second report was created was simply to protect the identity of an undocumented worker who did not want to have her name mentioned or to be involved in the case of this sort of profile. I'm also reminded, Your Honor, that we, upon learning, and this morning when we were looking at the documents that we turned over to the prosecution, learned for the first time that, in fact, to our surprise, the July 29 statement was not the one that had been turned over, but it was this August 18 statement, and that was then the reason for the added delay while we brought that up to the court and then voluntarily turned that document over to the prosecution.
Ms. Clark? Certainly.
I feel like I'm experiencing deja vu. All over again. That's right. Mr. Douglas stands before the court once again to fall on his sword. I guess he's elected to do that. That's his job in this trial. I'm not impressed. I think that these representations by counsel are unavailing to alleviate the problem that they have created by willfully failing to disclose material statements. This July 29th statement is not only, counsel wants to represent to us that the August 18th statement was more detailed and had more relevant information than the July 29th statement. When I went through and compared the two statements, what I found was that actually, in most relevant respects, the July 29th statement was far more detailed. And there was one obvious omission in that July 29th statement, and that is that at 10:15 to 10:20, on July 29th, Rosa Lopez said she went out to walk the dog and made no mention of seeing the Bronco at all. That statement is totally absent from the July 29th statement. Only on the August 18th statement does it state that she went out to walk the dog at 10:15 to 10:20 and saw the Bronco. Obviously, we have some material discrepancies of a very important nature. Discrepancies that we should have been informed of quite a long time ago. Discrepancies that would have allowed us to address Ms. Lopez in a far different manner. With respect to the greater detail in the August 18th statement, let me point out that it was only the July 29th statement when she made mention of what kind of shoes she was adamant the prowler was wearing. August 18th says nothing about that. The information concerning Detective Mark Furman in the July 29th statement is no different. In fact, it states that it was conclusively Detective Mark Furman she spoke to, whereas in the August 18th statement it says that he was subsequently identified as Mark Furman. And lest there be any mistake made here, Your Honor, the August 18th statement makes no mention of a July 29th interview, and the August 18th statement states specifically that it is not an edited version of a prior statement, but it was a statement generated by Rosa Lopez on August 18th. So we have not only willful failure to disclose the July 29th statement by their late presentation today, but we also have a deliberate material misrepresentation implicit in the August 18th statement, in which it purports to have interviewed her once and only once, and that was on August 18th, deliberately misrepresenting and misleading the people to believe that there was only one interview. Now, what makes that an even more gross lie is that both statements were taken by the same investigator, Bill Pavlik, given to the same attorney, Robert Shapiro. Obviously, counsel knew, obviously Pavlik knew that there was a prior statement, and there's no mention of that. This is a material misrepresentation in and of itself. And as officers of the court, they should be ashamed. They should be embarrassed. In fact, their bar tickets should be hanging in jeopardy at this point for this kind of misconduct. And this is misconduct. There's no question about it. The question is what the court wants to do about it. It's another issue. But I am appalled. I am appalled as an officer of this court that these kind of misrepresentations would be propounded in the manner that they are, with these sanctimonious denials and claims of being fair-minded and open-handed and forgetting that there was supposedly a witness who would corroborate at least some aspect of Rosa Lopez's statement. Obviously, Rosa Lopez put this person into her July 29th statement for the express purpose of showing how credible she was. And when the defense found out that Sylvia was not only not going to corroborate Ms. Lopez, but was going to say she's a liar and no such thing ever happened, and I wasn't at her house, and I did not make an observation of the Bronco, she conveniently disappeared from the statement. That's the truth. All we knew, and counsel wants now to point the finger at us to try and put us on the defensive after their misconduct, which is reprehensible in itself. I would like for the court to know what that situation was. What happened is that we received a clue to talk to a maid named Sylvia, who said that Rosa sold her story for $5,000. And that's what we did. We interviewed a maid named Sylvia, who lived close to the Rockingham address of the defendant, and she denied having spoken to Rosa. She denied having any close relationship with Rosa Lopez. She denied having any knowledge of the case at all. She said she did know Rosa, but having ridden the bus with her a couple times, and that's all she knew. And so there was nothing to generate, because all we did was follow up a clue that wound up being, I have no information. We had no idea, because of the defense misconduct, that Sylvia was somebody who had some material information Rosa Lopez claimed. And so all we were doing was following up a tip that didn't pan out. Had we known that Rosa Lopez made this statement on July 29th, claiming to have visited, and now the defense wants to downplay her importance, and they want to downplay her importance in order to, this is going to be how they cover up, how they explain away, yet another way we're going to expose Rosa Lopez as a liar. This is, now we've got their cover story. The court's heard it. That this woman doesn't want to get involved and she's an illegal alien. Illegal aliens tell the truth too, Your Honor. And I'm sure that Sylvia will tell the truth if asked, whether or not she was with Rosa Lopez that night. But obviously, she becomes a source of impeachment material.
All right, two questions then, Ms. Clark. Are we confident in our determination that the Sylvia mentioned in the report from July is the same Sylvia that the tip was followed up on?
We have no way of knowing that. Because the defense hid this report from us, we have no way of knowing it this time. We're going to attempt to find out.
Okay. Second question. Although from Mr. Douglas's comment, I take that to mean that apparently it's the same person.
It would seem they are saying so.
All right. Sure.
I also would like to point out to the court that we have an inconsistency even among defense counsel.
Ms. Clark, I just had two questions.
I'm sorry.
Let me pose my questions to you. I just wanted to see what your level of confidence was in that Sylvia is the same Sylvia. You seem to have a fair degree of confidence that we're talking about the same person. Secondly, my second question, let's assume that I agree with you that this is a delay in discovery that is substantial and should not have occurred, especially in light of what transpired earlier, calling upon your first observation that this is deja vu all over again. What sanction, if any, do you seek at this point, since that's really the bottom line
Yes.
of our discussion, I assume?
Okay. Let me address the points seriatim. Number one, only hearing Mr. Douglas's statements now did I gain that confidence. Prior to coming down to court and hearing him make those statements, I didn't. I wasn't sure. I asked the investigator.
During the course of cross-examination of Ms. Lopez, assuming we go forward today, we can flesh out who she is
I'm assuming that.
and then confront her with any contrary views expressed by Sylvia, quote unquote.
Right. Of course, thanks to defense counsel's misconduct, we are going to be doing that in the blind. And as we all know, lawyers should not be asking questions on cross-examination for which they do not have answers. And what counsel has deliberately done is force us to do that very thing. So, number one thing, I want to point out to the court on how many occasions in the past we have asked for the notes, tapes, prior to other statements of this witness, specifically this witness. We have requested them. They were denied to us. This morning, Mr. Cochran came in and told the court that he first learned of this other statement today. And now Mr. Douglas tells us he knew about it all along. We have inconsistencies between counsel. And we now have to race the tabloids in order to find out where this Sylvia is, who she is, and what she'll have to say. I mean, really, we are put behind the eight ball in a very serious way. And Mr. Douglas's elaborate dance doesn't cloud the fact that we're put behind the eight ball with this. I think that here's what I think would be the fairest thing, is to preclude counsel from using this as a prior consistent statement, which is in any case, legally it doesn't amount to a prior consistent statement that would be admissible for corroboration, because it does not arise at a time prior to the genesis of the bias. But in any case, if they were attempt to use it in any form, it should not be admissible as a prior consistent statement. Furthermore, Yes. Furthermore, they should be precluded from ever calling Sylvia. And we should be permitted to cross-examine on this July 29th statement at our discretion. We would further ask the court to admonish the jury that we have a willful and intentional disobedience of a court order in the delaying tactic of the defense in turning over this report, which delaying tactic was engaged in for the purpose of gaining a tactical advantage in the case and taking the people by surprise, and in an effort to curtail their effective cross-examination of Rosa Lopez. And I'm reminded that perhaps this would be the time, Your Honor, to lift the discovery sanctions imposed upon us some 2 months ago.
With domestic violence all over again, wouldn't we?
Revisit, yes. But at least that would allow us to present witnesses and try the case in the manner that we had, closer to the manner in which we had anticipated doing. It's now been 2 months. Counsel was afforded the opportunity to investigate those witnesses. Now they have had all of the time that the court deemed appropriate. I think the court said 6 weeks. It's been longer than that. And we should be permitted, I think, at this time, to be able to put those witnesses on.
So as I understand you correctly, then your position is that you want me to restrict or prevent the defense from using the July 29th statement as a prior consistent statement, should that come up. You want me to preclude the use of Sylvia as a defense witness.
That's correct.
You want me to give an instruction to the jury regarding another violation of the discovery rules, and you want me to lift the previous sanction regarding the witnesses that were belatedly disclosed by the prosecution, correct?
Right.
All right.
Which I'd like to underline one thing to the court. When we say belated in the People's case, there was a 2 to 3 week delay. We're not talking, the defense delay is more like an ice age compared to that. You know, I mean, we're talking 8 months, Your Honor, 8 months that they sat on a statement that at least one of them knew they had. A statement that was prepared by the very same investigator who prepared the August 18th statement. I mean, this is so obviously willful. This is so obviously intentional, a disobedience of the court's order, that I am shocked. I am shocked. I have never seen a defense attorney behave this way. I have never seen this happen. You know, I've heard of delays. I've heard of refusal to take statements. I've heard of a lot of things. But I've never seen this. And I've never seen it in such a blatant form in an effort to sandbag the prosecution, to blindside us. You know, they're obviously very desperate, you know, to engage in such obvious tactics, but they should be unavailing. After the repeated requests by the prosecution for notes, tapes, and other reports on witnesses, and particularly this one, and the denials of defense counsel that any such thing existed, only to have the 11th hour report come out,
Well,
I'd
counsel,
ask that...
let me tell you what concerns me the most about that. After having said all that, and forgive me for interrupting you, but a more pertinent point is that after we had that last episode, I then directed defense counsel to go through and make an inventory of all their witnesses and statements, because I wanted to avoid specifically what we have here. That's what concerns me more than what you just mentioned.
Right, right. And because I was not charged with the responsibility of compiling the inventory, the pain of that effort caused me to forget that the court had made that order, and that makes it even worse. That's right. Because who knows what else they have? Who knows what else they're sitting on? So I would ask the court for this. I would like their investigators to come into court and divulge to us all of the reports and notes and statements that they have taken on the relevant defense witnesses that we will designate, so that we can get a complete and accurate idea of what else they've got that they have not turned over. Because I think we still have not seen the end of this.
All right.
We need Rose's notes, by the way. We know that she's been extensively interviewed by counsel. I cannot believe for 1 minute that there was no note taken, no tape made of any statement that she gave, especially over this last weekend. So, I mean, there are considerable notes and statements that exist on this witness that we have not been shown. And the defense counsel, if they want to get up and deny it again, we're going to revisit the issue again. But I would hope that the court's sanctions would be much more draconian. And I would ask that before we proceed, we hear from these investigators. I want to see. I think the court should see what else they've got. And I don't know if we'll ever find out, but we can try.
Mr. Douglas?
A couple things come to mind, Your Honor. There are a few occasions in court where I felt as bad as back in January when I had to suffer the slings and arrows for things that occurred. Therefore, Your Honor, I would not willingly or intentionally thrust the defense into a position where I find myself again having to explain something such as this. When the court admonished defense counsel to seriously and cautiously review the discovery and to create a book and to set forth all of the documentation, I did that and I complied with the court's direction in that regard. There was, Your Honor, in my records, a 2-page interview from William Pavlik to Robert Shapiro concerning Rosa Lopez. I then checked off that consistent with a 2-page interview from William Pavlik to Robert Shapiro that had been turned over to the prosecution. It was only this morning, Your Honor, that I saw for the first time that the 2-page interview that we had given to the prosecution was not the same 2-page interview that I had been using in my notes. Your Honor, I stand before this court as an officer of the court to tell you that I never had in my possession the August 18th statement until I went back at direction of Mr. Cochran and checked to see what document it was that had been given.
Mr. Douglas, let me direct your attention to one other thing that I'm more interested in. Let's assume that we both agree, however, that this is a late disclosure, because there is some difference, significant difference between these two statements. So you and I both have to agree that the disclosure is late in coming, correct?
Yes, Your Honor.
All right. Putting aside the explanation as to how that happened, the prosecution has asked for 4 sanctions as a result of this. What's your response to their request for these 4 sanctions?
I do not think, Your Honor, that it justifies bringing in investigators and having investigators share intimate attorney-client work product with the prosecution. There are no notes that have not been turned over. There are no tape-recorded statements of Ms. Lopez. I'm not sure, Your Honor, how the prosecution speaks to a witness that they are going to call when there are attorneys present. We sit in a conference room and basically discuss questions that will be asked, answers that are going to be given, but we're not taking down notes such that it would be the kind of thing that they're talking about. So I'm not sure what they are talking about. There is no tape recording of Ms. Lopez by any of our investigators. We turned over, Your Honor, the July 29, 1994 statement.
Mr. Douglas, that's really another question that you're addressing. I want you to address the 4 specific sanctions that the prosecution has asked for in light of the delay in disclosure. The other issue as to whether or not we're going to talk to Mr. Pavlik or the other investigators to ask them to disgorge anything else that they might have as to any other witnesses, that's interesting. That's something we'll take up at a later time. I'm more interested in getting your response to these 4 requests.
Very well, Your Honor. Can you remind what the 4 were?
Number 1 was that you be precluded from using the July 29th statement as a prior consistent statement. Number 2, that you be precluded from using Sylvia, quote unquote, as a defense witness. Number 3, that the court give an instruction to the jury that there's been a willful failure to disclose the prior statement of Rosa Lopez to the jury. And 4thly, that the court lift its previous sanction on the prosecution for their delay in disclosure and allow them to now present the witnesses that were late in being disclosed.
I think, Your Honor, I will answer this question, and I think the court should understand some context so that you could weigh the appropriateness of any particular sanctions. What we are doing is creating a conditional examination record that the defendant will use in his case, now we're learning, will come at a minimum of 6 weeks from now, if not longer. If there is the court's position that some sort of a sanction would be appropriate because there may be some measure of prejudice with the people being unable to specifically question this Sylvia, and we have not interviewed Sylvia, Your Honor, we have not contacted her. I'd like to make that clear as well. I think that the appropriate sanction would be consistent with that which was imposed on the prosecution. That is, creating some time frame within which the defense would be barred from offering that videotape until there has been a showing that the people have had an adequate opportunity to investigate this Sylvia, to obtain a subsequent statement from her, and are now adequately prepared to rebut anything that may have been said about Sylvia in Ms. Lopez's statement. It is important to remember, Your Honor, that we are not intending to bring any circumstances of Sylvia's involvement in our case through the testimony of Ms. Lopez. Our entire testimony is going to be based on that which is included in the August 18, 1994 statement, which is why I say that statement is more complete for the purposes of her testimony than even the statement from July 1994. I do not think, Your Honor, that it would be proper to preclude Sylvia from being called as a defense witness, because I think that would be a premature ruling at this point. It may be that she will have nothing that we are going to offer in corroboration of Ms. Lopez. It may be that she will. I would urge the court to withhold that particular consideration of the sanction until we get to that point, and to require that we would be obligated to inform the court beforehand. This Sylvia is not on our witness list. We have no document from Sylvia. I cannot represent to the court that there is even a present intention to call Sylvia in any regard. I suspect, because she is undocumented, that she is not going to be very interested in involving herself in a case of this profile, and I suspect that we would not anticipate calling her as a witness, but I do not think it be prudent at this point to commit to that particular sanction. As to the final sanction, that is, that they should now be relieved of their obligations, the court has always made it clear that we can't confuse apples and oranges. The court imposed a sanction that the court thought was well-fashioned and well-based. Given that record, I would urge the court to impose a sanction that is similar given this particular record, and that is the advantage that we have now of having a conditional examination. She is not going to be testifying in front of the jury. It is not, for example, a situation where prior to her going away for the day, after her direct has already been placed in front of the jury, we now say, oh, by the way, we have this statement. When we learned about this statement, when we learned that they were different, we then first brought it to the court's attention to see, for the court preliminarily to rule whether or not there was an obligation to release the statement. Certainly, Your Honor, I understand and appreciate the scorn that would befall me for explaining the circumstances of this. But this was not intentional, Your Honor. It was not willful, and certainly this court has had some ability to gauge the nature of the defense effort, understanding that it is very much a monumental effort. But this was a matter that we brought to the court's attention before the witness was called to testify. And I do think, Your Honor, when the court is trying to balance and to interpret and to read between the lines, there should be some understanding place that the defendant did in fact come forward with this evidence, this information, and offered an explanation to explain it, though certainly not just a justification that the name was in fact missed. I do think, Your Honor, as well, that it would be totally improper, given the current state and where we are, for the court to issue an instruction to the jury that there has been some further willful misconduct. The reason why the court felt it appropriate earlier to issue a curative instruction was because there had been statements made concerning Mary Ann Gertjes to the jury, and the court realized that we could not unring the bell. there has not been anything said about any Sylvia, any mention to the jury at all of any connection that she may have. Her connection at best is only tangential and is not one that we intend to elicit on direct examination. So I do not think that there is the showing that we have in any way taken advantage of this slip, as the showing that was made in the earlier example, which then in the court's mind justified the imposition of that sanction.
Thank you, Counselor. All right,
Now, do you have points taken out to the court?
one thing.
Okay. I find it very, very impossible to believe that the defense did not follow up to interview a potentially corroborating witness for someone who is their key alibi witness. And Mr. Douglas's efforts to convince this court to minimize the importance of Sylvia to the defense should not be accepted on face value. It's clear that she is somebody that they would like to rely on and probably did interview and rejected because she dumped Rosa Lopez out as being a liar. And I'd like to point out to the court that the defense came forward this morning only after it realized in fear that once Ms. Lopez was cross-examined about how many times she spoke to their investigators and when, that their subterfuge was going to be exposed. Had we done the conditional exam on Friday night, Your Honor, she would have been here and gone, and we would never have realized that there was another statement given by her. So the prejudice could have been severe.
Tired.
Pardon?
Never mind. All right, then I take it, Ms. Clark, that since you were asking for these various sanctions, Mr. Douglas is correct that I need not impose any of these sanctions except for the one lifting your order of proof unless and until the defense chooses to present Rosa Lopez's 1335 statement, correct? I mean, I think you agree with that timing-wise. All right, then I would propose that we go forward then with the 1335 with Rosa Lopez at this time.
There's only one thing that I would request at this time, Your Honor, and that is that the investigators be brought into court and required to divulge the information with respect to any other notes, reports, or interviews taken.
All right, we can take that up later, but I would like to get the 1335 in the can, so to speak, if we can do that.
I'm sorry, Your Honor.
I would like to get the 1330. We will take that issue up, whether or not there is any, because what has transpired obviously causes me some curiosity and concern as to whether or not there's anything more out there that we ought to know about. I agree with you there. But I would prefer to use our time today getting the 1335 in the can.
The problem is that we're talking about our right to cross-examine this witness. If there are other reports and notes of her made by the investigators, we obviously need to know about that before we cross-examine her.
Well, the representation that's been made by Mr. Douglas is that there are no such other reports.
Which has been made
And
before,
notes.
specifically with regard to this witness. And this morning. That would, Mr. Darden came into court and requested any other notes or reports, and we were given a very assured, confident statement that there was nothing else, only to be confronted at the 11th hour with this other statement that came floating out. So I don't think we can
All
accept
right, so you'd
counsel's...
be satisfied with Mr. Pavlik coming in and telling us on the record that that's all there is?
Under oath, yeah. The other sanction that would be applicable to the conditional examination, Your Honor, is the use or mention of any of the statements contained in the July 29th statement. Any reference to those as a prior consistent statement.
I would say this, though, Ms. Clark, that we can go forward with a rather broad range during the 1335 because that is a statement that will not be offered unless until I find there's good cause, and it's still subject to editing for objections and other sanctions. I think because I have the impression that you would like to cross-examine her on the July 29th.
That may be true. Especially in light of the fact she doesn't see a Bronco.
If you cross-examine on it, then they are entitled to go back and reestablish the complete statement of what's there. Now, whether or not that comes in before the jury is another question. But if it's in the can, at least I know it's there.
Okay, then what about the...
All right, but I will ask Mr. Pavlik to come in and to respond to the question whether or not there are any other items with regards.
Is that the only... Or Mr. McNally as well, Your Honor? We have two.
I don't believe Mr. McNally is employed by the defense any longer.
He's referred to in the August 18th statement as one of the interviewers.
I don't believe he's here, and I don't believe he's in the employ of the defense any longer.
He's been in court the last week.
No, McKenna. That's McKenna. That's McKenna. Is
Mr.
there any way, I'm sorry, but is there any way that we can get some kind of statement from the defense concerning Mr. McNally's notes and who they were turned over to? Perhaps Mr. Pavlik's in possession of them? Obviously, he was engaged by the
Well,
defense back at the...
Why don't we just, let's ask Mr. Douglas, is Mr. Pavlik available?
He can be available, Your Honor, yes.
Not 3 o'clock.
Well, I'm going to propose a modification to our court schedule today to go to 4:30 since we're getting such a late start. Any objections?
No, Your Honor.
No, Your Honor, except that we want to hear from Mr. Pavlik before we begin cross.
All right, well, let's get the direct, and Mr. Shapiro, would you make a phone call to Mr. Pavlik, have him come to court forthwith, and we'll commence with the direct examination, and I'll take a recess between the direct and the cross-examination so that we can address the Pavlik issue. But I would like to get started with this.
One thing, Your Honor, I'd like the record to be clear is we have not interviewed this person known as Sylvia. We do not know
I got
her.
that the first time.
Well, Your Honor, the suggestion that I'm lying when I say that offends me. So I want to make
Well,
sure that
Mr.
it's
Douglas, let's be very clear. I have not imposed any sanctions yet.
Yes, Your
I
Honor.
haven't made any findings yet, so let's not get too excited at this point. But I am concerned for the reason I mentioned.
I respect it, Your Honor.
Thank you. All right, Mr. Schuman, Mr. Firth, are we ready? All right, Mr. Cochran, I'm sorry. 2 minutes? I'll stay here so we don't all have to go out and come back in. No. We'll take one break. Let me know, though. And, Madam Interpreter, let me know if you need a break. All right. And Mrs. Robertson, let's get the interpreter a glass of water, please.